Welcome to this mock trial video on Neer versus Minnesota, a landmark case on freedom of the press, presented by the World Affairs Council of Austin. Neer versus Minnesota in 1931 began as a civil injunction filed by the county attorney. J. M. Neer, publisher of the Saturday Press, was accused of printing malicious and defamatory articles. The county attorney sought to shut down the newspaper under Minnesota's Public Nuisance, or GAG law, of 1925. The Saturday Press was known for its sensationalist nature and attacks on local officials, accusing them of protecting gangsters. County Attorney Floyd Olson filed a civil action, claiming the paper was a, quote, public nuisance under the Minnesota GAG law. Neer argued this law was being used to silence criticism of corrupt officials. In 1927, the Minneapolis Tribune published articles about a murder club. In retaliation, the Minnesota Attorney General invoked a state law authorizing a permanent injunction against any newspaper publishing scandalous material. J. Neer sued, arguing this injunction was an unconstitutional prior restraint on speech. The case of Neer versus Minnesota marked a seismic shift in First Amendment law. J. Neer, the publisher of the Saturday Press, challenged the Minnesota Public Nuisance Act after it was used to ban his circulation. The Supreme Court eventually struck down the law, cementing the principle that the government cannot suppress speech in advance. In Hennepin County District Court, the judge ruled against Neer, declaring the paper a public nuisance and issuing a permanent injunction. The Minnesota Supreme Court affirmed this decision. Neer then appealed the case to the U.S. Supreme Court. Let's examine the arguments and witnesses presented by J. Neer in this critical case regarding freedom of the press. Neer's theory of the case argued that the GAG law violated the First Amendment by imposing prior restraint. He maintained that the government cannot shut down a newspaper before publication, and that the proper remedy for defamation should be libel suits, not censorship. Neer argued that the Minnesota law constituted an unconstitutional prior restraint, which is generally prohibited under the First Amendment. He contended that the law was used specifically to silence political criticism and expose corruption among officials. The state of Minnesota defended its public nuisance law, arguing it was necessary to stop defamatory publications. They claimed the press must not defy state authority, and that publications inciting public unrest could be legally silenced. Floyd E. Miller testified as a witness for J. Neer, supporting Neer's claims of corruption. Miller claimed the county attorney was complicit with criminals, thereby supporting the newspaper's allegations of graft. John Q. Whitmore, another witness for Neer, claimed the state attorney was complicit and protected local criminals. This testimony further supported Neer's claims that local corruption was being covered up. J. Neer testified that the law was being used for censorship and to protect corrupt local officials. He maintained that his articles were necessary political criticism, and the government cannot shut down a newspaper before publication. Howard Guilford, Neer's co-publisher at the Saturday Press, provided key testimony supporting Neer's claims of corruption. His statements reinforced arguments against censorship and helped establish the paper's allegations of graft. The witnesses, including Floyd Miller, John Whitmore, and Neer himself, reinforced the argument that the Minnesota law was an unconstitutional prior restraint. They claimed the law was being used to censor political criticism and protect corrupt officials. The central constitutional question was whether the Minnesota Public Nuisance Law violated First Amendment rights. The core issue was if prior restraint was a constitutional use of state power that infringed on freedom of the press and speech. The case hinged on the question of whether the Minnesota GAG law was an unconstitutional prior restraint. Could a state permanently enjoin a newspaper for defamatory content without violating the First Amendment's freedom of the press? Next, let's review the arguments and witnesses presented by the state of Minnesota in Neer versus Minnesota, a landmark case on press freedom. Minnesota's case theory was that the Saturday Press repeatedly published false and inflammatory accusations. They argued the GAG law was necessary to protect the public, and that the injunction was a remedy for the abuse of press freedom, not censorship. Key witnesses for Minnesota included Mayor George E. Leach, Police Chief Frank W. Brunskill, and County Attorney Paul N. Granger. They testified that the Saturday Press published scandalous, defamatory, and false information that harmed the reputation of the city and its officials. Businessman George H. Sullivan testified for Minnesota, supporting the state's public nuisance argument. His testimony reinforced the decision to silence Neer's paper and defended the constitutionality of the GAG law. The state of Minnesota defended the public nuisance law as necessary to stop scandalous and defamatory publications. They argued that publications causing public unrest could be silenced, asserting that the press must not defy state authority. Frank T. Gallagher, a witness from Minnesota, defended the state's public nuisance law. He testified against the Saturday Press, supporting the action to silence defamatory papers. Paul N. Granger, a witness from Minnesota, defended the public nuisance law and supported silencing defamatory papers. His testimony reinforced the state's argument that the newspaper was a public nuisance. Former Mayor Schulze supported Minnesota's position and defended the use of the public nuisance law. His testimony reinforced the argument for silencing Near's paper, supporting the claim that it was a public nuisance. This scene marks the transition to the next set of arguments in the video. Police Chief Brunskill, one of the officials Near accused of corruption, testified for the state. His testimony supported the injunction against the newspaper and reinforced the public nuisance argument for censorship. Mayor George E. Leach, another official accused of corruption by Near, testified for Minnesota. His testimony supported the injunction against the Saturday Press and reinforced the state's public nuisance argument. Minnesota defended its public nuisance law, stating it was used to stop scandalous and defamatory publications. They argued that publications causing public unrest could be silenced, and the press must not defy state authority. The Hennepin County Court ruled against J. Near, declaring the Saturday Press a public nuisance. A permanent injunction was issued to stop the publication, enforcing the Minnesota Public Nuisance, or GAG, law. The Minnesota Supreme Court upheld the lower court's ruling, affirming the permanent injunction against the newspaper. The court ruled that the public nuisance law was constitutional, supporting the state's use of prior restraint. The key question before the U.S. Supreme Court was whether the Minnesota GAG law was an unconstitutional prior restraint. Did the law violate the First Amendment's freedom of the press by permanently enjoining a newspaper for defamatory content? The U.S. Supreme Court ruled in favor of J. Near, deeming the Minnesota GAG law unconstitutional. The decision established a strong presumption against censorship, holding that prior restraint on publication violates the First Amendment. The majority opinion ruled the Minnesota law unconstitutional, establishing a strong presumption against prior restraint. It affirmed that prior restraint violates the First Amendment freedom of the press and cannot be used to prevent political criticism. In the dissenting opinion, Justice Butler argued the GAG law addressed an abuse of the press and was constitutional and necessary. The minority did not view the law as an unconstitutional prior restraint. The court noted that prior restraint is permissible in a few extreme cases involving national security and public safety. These exceptions include suppression during wartime or in cases of direct incitement to violence or overthrowing the government. The ruling in Near v. Minnesota cemented the general prohibition against government censorship. It established the core of modern First Amendment law, guaranteeing freedom of the press in all 50 states, with a strong presumption against prior restraint. This concludes our video on the landmark case of Near v. Minnesota. Thank you for watching.